Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book which has come to us from Globe Law and Business. This is an important book, and it's a book again for the legal business community. It's called CARVE-OUT, M&A, that's mergers and acquisitions, transactions. An important book. The consulting editor on this is Robbie McLaren. It's a practical guide and one that I think will be of great use to quite a large number of people, because the standard of work that Globe Law and Business produce is extremely helpful to, I think, a very wide range of people, both within the legal profession itself, solicitors mainly, but certainly counsel will be involved to a certain extent, and also, of course, to the admin business side. Now, Elizabeth and I talked about the book, and she was the lead author on this work, and she's given it the title Expert Advice and Consultancy on Complex Mergers and Acquisitions Transactions. Let's have a look at the book first of all. Here it is. It's a light book, it's not very big, it's a hardback. The house style, as you can see, very much of Globe. Practical guide and so forth you've got there. Then you've got you can just make it out, the spine, and then at the back you've got reversed out again on a dark background, the white. It should be able to be relatively easy to read, although I find the typeface on these very, very small, very difficult sometimes to read. Now, this is very much the house style of Globe. You can see they've got, I'm just going to give them a plug because they've written some excellent special reports. You can see some of these, some of them we've reviewed, pitching for lawyers and so forth. Very useful indeed. Then you've got Modern Legal Practice, which is a publication of theirs. Then as you get with the style, you get a detail about Globe Law from Sean O'Neill, who is the managing director. And Sean has kindly sent us this book for review. There's an index here, which is quite useful. It's only a short index by page numbering, but it is quite helpful. And then you can see, just showing it there, you can see the size, and it says, please note that page numbers in italics denote figures and tables. Then you've got a bit of detail about the people who are involved in the production of the book, because there's more than one person. It's obviously being edited by Robbie McLaren, but what you've got is quite a large number of people who are involved as the contributors. They're all listed there alphabetically. I can't go through them by name because there are too many. Then you've got an appendix at the back, and you see part B. This is about services provided by the purchaser in certain circumstances. Then you've got part A, services to be provided by the seller. So you've got a rather nice little comparative set of tables right at the back. And again, it's just part 2, detailed service provisions, a sort of breakdown which you've got there. And then before that you've got again appendix 3, transitional service conditions. I'm working backwards at the moment. You can see how it's going. If I now go to the front, you can see there's the actual front page, very much the house style of Globe. Then the blurb from Globe, and you can see there that you've then got the table of contents, an introduction, then the various chapter headings, if you like, if you want to call them those, and you've got the names of the people who have contributed to the individual chapters, and you can see the names of the companies they've come from. And again, you can see right at the back. You then move on to an appendix, which is the carve-out checklist, appendix 1, then the carve-out strategy and planning and so forth, then transitional services, which you saw as a table. Then there's an introduction from Robbie setting out what this is all about. Cross-border carve-out transactions have been a recurring theme throughout my career, he says. The first transaction I led at the very start of my career to the most recent deal prior to this publication. Each and every transaction has brought its own unique factual challenge. Obviously there's risk and all sorts of stuff. Then you read on. Then you see what has been happening in this particular area. Then you get on to things like conditionality, which is looked at by a very specific team within this firm of Latham and Watkins, where Robbie comes from. Now you can see that's how the book is structured. Now let's have a little look at what we think of the book from our point of view, basically, because this is expert advice on M&As. And they're a complex area, not an area that everybody understands, but buying and selling, whether it's bread and butter, books or large corporate entities, is the basis of any economy. However, as transactions become more complex, so do the legal landscapes worldwide which regulate them. And remember, we're in the era of regulation of everything. Although some things are outside it, which perhaps shouldn't be, and some things are over-regulated when they shouldn't be either. But we are in that era at the moment, so we have to recognise it. And among the most complex transactions that you can have are M&As, mergers and acquisitions. And I'm going to call them M&As from now on because we know what they are. But it may be that some people are looking at this for the very first time and may not follow part of what I'm saying. So I'm trying to make it relatively understandable. Even more complex than just transactions concerning a merger or an acquisition are what we call carve-out M&As. Hence the title of what is a new and a very specialist legal title from Global Law and Business. Very glad that Sian and her team, Nicola, have produced this, because I think it's very, very helpful to give you an idea of what is happening. Again, with some of the other titles we've been reviewing recently, there's a lot of stuff moving quite quickly at the moment, and I think it's useful to keep up to date where one can. As the editor then, Robbie McLaren, explains, quote, "This book is not intended as a guide for more straightforward M&A transactions. Instead, it seeks to assist M&A practitioners engaging complex M&A transactions, both in-house and in private practice." And as I said right at the beginning, if you read the introduction, he's the guy who's got the knowledge. And certainly it's well worthwhile. We've got a lot of expertise coming here. Well worthwhile listening to what he has to say. Technical though it is then, this is a compact volume which nevertheless offers, I think, a wealth of guidance, advice and background information, especially to those relatively new to this area of law, because it is basically an area of law, but it is about the deal, remember, as well. I had to say that just in case Mr. Trump ever watches this particular video or reads the book. You don't necessarily need to be an expert to glean a great deal from it then. In other words, it's pretty simple. When you start looking at it, you think, oh, this is very complex, but it isn't. It's actually very well written, and it's pretty easy to understand. Here then is a compendium of expert consultancy from almost 30 contributors, without which this book would not exist, adds the editor. Carve-out transactions, he says, are becoming more prevalent and even more complex, especially as many of them are cross-border. Interestingly, he notes that one of the key trends accelerating this growth are activist investors, and there are a lot of them. As their numbers grow internationally then, these investors increasingly require boards to look more critically at their portfolios and product mix, because we're in a global community. So it's further pointed out that if a board ultimately decides to divest non-core products, it's rare that this does not involve some kind of carve-out or separation. Now, I don't want to use other words here. I could do, but I'm not going to, because we are talking here about a carve-out. We're not talking about asset stripping, because that, I think, would be, apart from being emotional, or motive, I don't actually think that that's anything like what we're trying to put across here, because it's really looking at divesting, if I can use it in a more of a legal term. The key question then, as discussed in the first chapter, is how much do I, as the buyer, need to pay, and how much will I receive, whether buying or selling? Obviously, sounds pretty straightforward, but isn't. You're warned that it is often more challenging to work out how to get from the headline valuation to the purchase price in a carve-out compared to the sale of an existing standalone business. And I think that is very important in terms of the general concept of corporate governance. Obviously we have the rules and the regulations, but it's, again, you're looking at the overall picture. Now, the value of this book lies in the wealth of insights it delivers into the legal, regulatory and practical elements involved in navigating successfully through the ins and outs of carve-out M&As, M&A transactions. Now, from here, let me just make one point. Locked box mechanisms and completion accounts mechanisms are only two examples which they look at. Now, again, this is getting technical immediately, but you will get an idea of what we're talking about when you see those particular areas looked at, and use the index if that will assist trying to get a balance as to what's being said. Further coverage in the book includes such topics as what are called separation pitfalls, protections, due diligence, we all know what that is, employment risks, antitrust, litigation, and so forth. Obviously, it could be antitrust litigation versus arbitration, which could also be looked at. Again, very popular internationally. Tax matters, of course, also covered, and a lot more as well. There's also a chapter on key differences between the United Kingdom and the United States of America practices, and I think again that will be of value. Let me conclude by mentioning, as I've probably said earlier and shown, there's a handy index at the back and 3 appendices which include, as I say, the carve-out checklist, which I'll have a look at in a minute, aimed ultimately, in the words of the editor, at achieving, closing and managing a smooth and pain-free separation. So for those involved professionally in the intricacies of this specific area of law, this book we think is an essential reference, and the publication date is cited at 2019. Let's just have another look at it. There it is again. See, let me just open it up. You can see there are some figure work as well, various things, use of warranty and indemnity insurance, very big area. There's a lot of legal issues there as well. But let me just go to the bit I referred to earlier, which is the Appendix 1 carve-out checklist. I think, again, very important. There's a note saying it's reproduced by kind permission of Latham and Watkins, and obviously it's their basic checklist, but it will give you some idea of what you're looking for. And I think they've been very generous in giving a lot of information, early stage preparation and so forth, and then commencing the sale process and all the way through. So I think you'll find it very helpful. Some very sensible, very useful information there for all to look at, and hopefully it will be a success. I'd like to thank, as I say again, Globe Law very much for producing these books. They're very helpful, and I'm hoping they will give you a great deal of additional assistance in what can be quite a complex area. But it's worth it in the end. Thank you to all. Bye-bye.